Respected Justice Kurian Joseph, the chair for this session, respected Justice Shah, Mr. Shetty, Professor Sir, and all the distinguished friends and colleagues who have gathered here. More importantly, all the young people. Usually we feel quite disappointed that most of the meetings we go to consist of older people like me and very few young people. That's a big comment we get. Now we have a very good representation of young people, and I think we're happy to see that. And more importantly, it is the extraordinary rapt interest and attention with these young people are listening to these proceedings from the morning. I think you need a round of applause for yourself, all the young people, because this gives me a lot of hope for this country. And I'm finding this everywhere, that everyone better watch out, because the young people of India are awake and are alert, and they are going to protect the future of this country. So I'm very happy to be here today. We heard a very erudite presentation from Justice Shah on basically an issue of how power is shared in the country. And the very important and consequential decisions that are about to be made after the first census is 2026 census is completed, that will change the number of seats that each state has in the Lok Sabha. And that will shift the power inside the country about over what law is made in the country, how our constitution can be altered. These are very consequential decisions. And the young people who are here should be particularly interested as they are, because it will have huge consequences for them for the rest of their lives. It will shape the kind of country that we will live in. So that's one dimension of the struggle for power, not just getting power through winning elections, but the struggle over shaping structures of power that is going on in this country. And the structure for power is shaped, for example, by how many seats every state has in the Lok Sabha. That's a structure within which we then are able to elect MPs and send our representatives to Parliament. We now look in this session at another very important structural issue on how power is allocated in our country. And that is the power involved in the relationship between states and center as far as the role of the president and the governor is concerned. How does that affect? What is the central issue here for the young people? The central issue here is we have a very strange provision in our constitution, and I'll explain why it is there. The strange provision is that one individual who is not elected but is appointed has the power to nullify and stop a law passed by an elected state assembly. At his discretion, he claims. So you have a state assembly that represents the entire people. The state assembly passes a law, and one individual who is not elected, not accountable to the people, serves by appointed by the President of India, and which is the union government, serves at the pleasure of the union government, can be removed at any point of time by the union government. That one person can simply nullify, veto the law passed by the state assembly. In a democracy, I mean, this is quite unheard of in a democracy where an unelected official can stop or veto the action of a legislative assembly. So if you and I, we campaign, we create public opinion, and we get our assembly to pass a law, this one person is sitting there as an obstacle to make sure that the law doesn't get passed. Now, how did we come to have such a provision in our constitution? That's very important for us to understand. This provision actually originates from the 1935 Act. The 1935 Government of India Act, which was the last sort of governance framework put in place by the British before independence, before we got independence from them. The Government of India Act 1935 said that the king will appoint a governor general, and the king will appoint a governor for every state. And these provisions and each of them will have a council of ministers, which will be elected partially. The ministers will be selected by the governor or governor general, but there will be assemblies, legislative assemblies, that would have been elected from a very limited electorate, not one person, one vote. Basically, the powerful people in the country would elect them. And when even that legislature passes something, then the governor general or the governor has the right. The British governor general or the British governor have the right to veto that and say, no, we will not accept that. That's not something unexpected in a colonial constitution. But how did this get put into our constitution without any change? And we are still living with it. Here we must recognize a couple of things. One is that there was a disagreement at the time of independence, very important disagreement between two groups of people. One group of people who wanted to see Indian society democratized, led by Dr. Babasaheb Ambedkar, who 11 years before independence called for the annihilation of caste, because he saw that this caste structure is the greatest threat facing this country, and it must be annihilated. So they felt that this is the priority for the country. There was another group of people who felt what India needed is top-down governance. Clever people, educated people, wise people, they will decide what is good for the country. They lay down policies, and they will get some legitimacy from some type of expectation, from some type of electoral process. But they must run the country. And they felt that this democracy of one person, one vote will result in anarchy. These illiterate, uneducated masses are not capable of making law and making decisions, so they have to be restrained. There will be anarchy. They are centrifugal. They will flee this country. They will break away from this country, so they have to be kept together. And for that we need a strong center. And they therefore kept the British provisions where the Governor General, who was succeeded by the President as the head of government, and the governor in the state would have these draconian powers of controlling the voice of the people, even though in British times it was limited, but here now we have one person, one vote. There are some members, I don't want to name them, in the Constituent Assembly who actually argued against one person, one vote, very liberal people who said, look, we are not ready for it. And fortunately, that view did not prevail. So there was one group of people who wanted to ensure that they had the capacity to control the masses. But there was another set of people, including Dr. Ambedkar, who felt that, and they were right, that the great strength of the feudal forces, the casteist forces, the feudal economic forces are strongest at the state and local levels. And if you decentralize to them, then the chances of bringing about a secular, democratic, socialist republic are actually less than if you centralize them and have a progressive union that will act against these dominant forces and create a more equitable and more egalitarian society. And this is what had happened actually in the United States, where after a period of time, the union became the main driver of progressive change. They used even the Commerce Clause in order to force civil rights litigation onto states, because states were autonomous and the union could not make laws for them. But they said if you engage in interstate commerce, we have jurisdiction over that commerce, and therefore we will, through that, bring in progressive legislation on human rights and civil rights. So they actually had a model, particularly Dr. Ambedkar, who is without any doubt the greatest constitutional and legal scholar that we've ever had in this country, one of the greatest constitutional scholars in the world. And he had very close understanding of and experience with the United States system. He studied in Columbia University, and he worked with very distinguished professors like John Dewey and others. He understood the American constitutional system, the British constitutional system very deeply. And so he felt that the better way is to have a progressive representative government at the union. So in 1930, in the Roundtable Conference, he said, we want electoral democracy, but we want representative democracy where every community in the country has due and adequate representation in the legislature, the executive, and in the judiciary. So through this representative democracy, we can use the power of the union to dismantle and annihilate caste and other gender and patriarchy and feudalism at the local level. So in a sense, there was an unlikely consensus between those who wanted to suppress the people and those who wanted to liberate the people to ensure that there was a strong center. But people like Dr. Ambedkar never had a fear that anyone would secede from the country, and that has proved to be right, because these progressive changes that were brought about by the union at the beginning, at the early stages of our republic, did have a positive effect in creating space at the local level, including through, for example, provisions on reservation and other kinds of social justice provisions that have created space for positive change at the local level. So Dr. Ambedkar was right, and it proved to be right. But then what happened later is that this whole understanding of the Constitution and our understanding of federalism, I think, lost its way. It became disconnected from the people's movements. We've heard with great respect Mr. Justice Chalmeshwar tell us that, look, we are not a federation because there were not units under the British or the Mughals, and these units did not come together and agree to form a union. But I'd like to argue, I was born in the United State of Travancore and Cochin. Justice Chalmeshwar said he was born in Madras province. I was born in a princely state. We had never had, other than some people from the Tamil areas, and we consider that we are all the same culture. So we never had anyone from outside this broader Tamil Kerala culture rule that part of the country ever. The first time that someone from outside that area ruled us, ironically, was on August 15th, 1947, when we became part of India. But we celebrated on the streets. We celebrated that we were brought under the rule of a union, that we were becoming part of a union. The British transferred sovereignty back to Travancore. And the Travancore Maharaja and government were given the option to become an independent country, and they wanted to do that. And they wanted actually to bring in an American-style, constitution that will have a very strong executive and very weak democratic institutions, and including Mr. Thomas Isaac, a very distinguished leader from our state is here, and he knows better than me. He comes from that area, from that district. But one of the reasons behind the famous Punapravaila revolt was actually to ensure that this idea of the Travancore government to become an independent republic and impose an American model of governance on Kerala was stopped, and people died. So if we are part of Travancore, it's not because of VP Menon, it's because of poor people who died in a revolution saying we want to be part of this union. We don't want to, so they were not centrifugal forces, they were centripetal forces coming together to hold this union together. Right. So the theory that we have to hold India together is really just an excuse for those who want to deny democracy to common people. Now, this provision in the Constitution, which basically has a very important difference, two provisions, one for the president and one for the governor. The president's provision makes it very clear that the president shall be bound by the aid and advice given by the Council of Ministers. The Council of Ministers presents a proposal or a proposed law to the government, to the governor, or the president, and the president can read it and return it and say, please reconsider. After reconsideration, if it is given back to the president, then the president is bound to assent to it. But that's not the case with the governor. The governor has a chance to simply, if the bill is passed and is presented to the governor, the president can agree, governor can agree, or the governor can simply refuse to agree, refuse to give assent. or if it is repugnant to, in conflict with any central law, the governor is obliged to refer it to the president to make sure that that repugnancy is addressed. So the governor has the provision that the governor is bound by the aid and advice of the Council of Ministers is not there like it is for the president. So that gives a loophole for the governor to argue that I have discretion and to expand that discretion very widely. And what we have seen now in today's context is governors, including in Kerala and in many other states, wherever there is a party that is ruling which is not part of the ruling coalition at the union level, then the governors are becoming very aggressive to assert their discretion, to filter the laws that are passed, to interfere in various institutions in the country. So we've had in Kerala the example where the governor is insisting on putting a picture of Bharat Mata in the Raj Bhavan and in all official functions. And Dr. Isaac's colleagues have strongly protested. They walked out of these functions where the governor is involved and saying, look, this has no place in a secular democracy. But the governor is using his discretion to impose all this on us. He's asking for religious education in schools. He's every day sort of bringing out ideas from his own personal agenda with whatever movements he's involved with. So this discretion is being misused. Now, what is important for us to recognize? This has happened in the past under the Congress government also. Governors have been appointed, dismissed, manipulated. All kinds of things have happened. Unsavory things have happened. But what is new now is that for the first time in the history of our country, a group of people who are sworn to, in the organization that they belong to, they're pledged to establish another kind of polity, another kind of state, a theocratic rashtra in our country, for which they have to overthrow our constitution, because it cannot coexist with our constitution. Either directly or indirectly, they'll have to overthrow the constitution. And my argument is that in these 10 years, gradually, the constitution has been pushed out effectively from the union and all the states that are ruled by the ruling party of the union. And the constitution is not available in full force, in effective force in any of these states. And so there is the constitution is dying in our country. It's dying in our country. And it's alive in Tamil Nadu, it is alive in Kerala, but the places where it's alive is still very, 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 very rare. And I do want to pay on behalf of all the people in this country. I'm no one to speak on their behalf. I'm only one of them. But I feel I'm speaking on behalf of a big section of the country when I want to pay tribute to Tamil Nadu for being on the forefront of the defense of secularism and democracy in this country. And that is not surprising, because what I would like to suggest is that we respond to this crisis by understanding our federalism in a different way and in a new way. We must understand the unit. I said, I'm from Travancore. Now, this Tamil culture, the Malayali culture, these are the units that constitute India. Not the units created by a Mughal or a British or someone else. They are not the units. We are ancient people, ancient populations, with our culture and our language, and Article 29 says distinct language, script or culture. Those are groups with distinct language, script or culture, distinct religions, distinct beliefs, distinct traditions. They are the units that constitute this union of India. And we cannot say this is not a federation, because a federation means, the Latin word federare means actually to ally, come together. These social groups have come together to create this union. And a union means a relationship between units. The movement that is now in control of this country believes that India should be a unitary state. Unitary state means all of India should be one unit. There is no place for union when there is a unit, because a union or a federation is a relationship between different units. Unless you have multiple units, there is no union. There is no federation. So they want to destroy all of us and create India into one unit. That's what's called unitary government, which to do this, they have to destroy our distinct language, script, culture, religion, everything that is important to us, our freedom, our Swaraj, which is what we fought for, our independence, which is what we fought for in the independence struggle. All this will have to be destroyed, and we'll have to be homogenized so that we can be ruled as one unit. Now, what we saw actually in the freedom movement was actually, we tend to forget that the freedom movement did not come in a vacuum. It did not come simply from the collapse of the 1857 First War of Independence. The freedom movement came from an extraordinary 19th century. The hallmark of that century was an anti-caste movement that was across this country, and this state of Tamil Nadu has played a very important role in the anti-caste movement, the self-respect movement, and Periyar and Annadurai and Kalaignar, all of these great Dravidian leaders have played a great role. And frankly, India's secularism, India's constitution is now strongly protected by this Dravidian movement. So this anti-caste movement of Srinarayana Guru in Kerala was the main foundation of this anti-caste movement in Kerala. Mr. V.S. Achyutanandan, the most popular communist leader we have ever seen, who died recently after many years of being unwell. And when he died, I think everyone was stunned by tens of thousands of people turning out on the streets to pay respects to him, and for hours and hours weeping and crying. 12 years ago, in an interview, Mr. Achyutanandan said, in his own words, he said, here in Kerala, what the Communist Party is doing, what the labor movement is doing, what the agricultural workers is doing, is to strengthen the Srinarayana movement. This was his view. And he said, this is why, or this is how we have a 1957 government, a communist government. So the way he saw it, he was a laborer, lost his mother at age 3, lost his father at age 11, studied up to 3rd or 4th standard, and emerged as one of the most powerful leaders of the state, because he realized that he was part of that broader anti-caste movement, a movement for an egalitarian society in which Tamil Nadu has been at the forefront through all your great leaders. So we must understand that our federation is not a traditional federation based on America. If you look at the Supreme Court judgments, you'll find they're all analyzed in terms of, is this an American model? Is this a British model? Is it a Australian model? And Justice Krishna Iyer evocatively once wrote, saying that is the Rashtrapati Bhavan Buckingham Palace, or is it the White House, or somewhere in between? But I think that's not the right imagination. I think the imagination is to understand that this is a federation of social movements and social groups, bottom-up social groups and social movements that have come together to form a union amongst themselves, independent of all these superstructure powers that come and go, rise and fall. There is a permanent unity between all the people of this country, as Dr. Babasaheb Ambedkar strongly asserted, that we are one people. What binds us as one people is this yearning for independence, yearning for dignity, yearning for individual freedom and individual self-respect, and to destroy structures that deny that to us. So I think we understand federalism in a new way, more like a warp and a woof in textiles, the warp and the woof. The vertical is the community, and the horizontal is the union. And together we form a fabric, the fabric of India. The warp and the woof of communities, social groups coming together, interdependent, and deliberately interdependent. I've read about how in Banaras the silk industry for centuries has been structured in such a way that something is done by the Hindu, something is done by the Muslim, something is done by someone else, so that you cannot produce that tapestry, that fabric of silk, without everyone coming together and cooperating, because there is an interdependence that has been built. And so we have this, what I would call a warp and weft federalism. That is different from the American federalism. That is different from the British federalism, different from the Australian federalism, which is a federalism that has emerged to keep together our diversity, our freedom, our individuality. And if there is any federation to which we can compare this, our federation, it is a federation, a union that emerged much after our Constituent Assembly and our Constitution, and that is the European Union. European Union has 27 countries with around 50 crores of people, 45 crores of people, and it has tremendous diversity in language, script, and culture, which they very strongly protect and maintain. That is the kind of federalism that we are trying to build. So for this purpose, what I would suggest, I'd conclude by suggesting two or three sort of three practical suggestions move forward. One is that we must start to reconceive the nature of federalism. And I think Justice Kurian Joseph is an ideal person who has a very broad social vision and a much broader vision of what goes on in this country, connected to the grassroots of this country, to think of how we can start to think of our federalism in a different way, not just as American, British, or Australian federalism, but as I said, as this woof and warp federalism, where we are coming together in interdependence. The people, the common people, a bottom-up federalism that we want. So rethink that concept and put forward a new, more democratic concept of federalism. And assert strongly, as the Supreme Court has asserted many times, that we are, without any doubts or qualifications, we are a federation, we are a federal nation, and we must protect and preserve this federal structure of the Constitution. There should be no doubt about it, number one. Number two, I would suggest that you may want to Tamil Nadu and other states, Mr. Isaac is here, may want to consider unilaterally, on a non-binding way, for the government and the assembly to come together and issue a code of conduct for the governor. What the governor should do within the Constitution. So for that, I'll just read out to you, Justice Krishna here has drawn what I won't call the Lakshman Rekha, I'll call the Krishna Rekha on what the government should do. I'll just read it out. He says, in the very famous 50-year-old Supreme Court decision, 7-judge bench, still the controlling law on the subject, called Samsher Singh versus State of Punjab, 1974. I'll just read a short paragraph with your permission from that. Justice Krishna says, we declare the law of this branch of our Constitution. We declare, Supreme Court declares, it's a concurring judgment, the law of this branch of our Constitution to be this. What is it? That the President and Governor, custodians of all executive and other powers under various articles, shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of the ministers. Only upon and in accordance with the advice of their ministers, save in a few well-known exceptional situations. Categorical statement. Categorical statement. Without being dogmatic or exhaustive, these exceptional situations are the following. Number one, the choice of Prime Minister or Chief Minister. Restricted though this choice is by the paramount consideration that he should command a majority in the House, he or she. 2, the dismissal of a government which has lost its majority in the House but refuses to quit office. 3, the dissolution of the House where an appeal to the country is necessitous. Although in this area, the head of state should avoid getting involved in politics and must be advised by his Prime Minister or Chief Minister, who will eventually take the responsibility for that step. We do not examine in detail the constitutional proprieties in these predicaments, except to utter the caution that even here the action, even in these exceptional cases, the action must be compelled by the peril to democracy, and the appeal to the House or to the country must become blatantly obligatory. We have no doubt that D. Smith's statement in Constitutional Administrative Law by S.A. D. Smith regarding royal assent holds good for the President and Governor in India. Then he quotes this and he concludes with that quote. Refusal of the royal assent on the ground that the monarch strongly disapproved of a bill or that it was intensely controversial would nevertheless be unconstitutional. The only circumstances in which the withholding of the royal assent might be justifiable would be if the government itself were to advise such a course, a highly improbable contingency, or possibly if it was notorious that a bill had been passed in disregard to mandatory procedural requirements. But since the government in the latter situation would be of the opinion that the deviation would not affect the validity of the measure once it had been assented to, prudence would suggest the giving of the assent. So very, very categorical. We must be clear what is going on now in the country is there is a misuse of constitutional power to destroy the Constitution. Deliberate misuse of constitutional power to destroy the Constitution. We've never encountered this before. And it's happening at different levels. So we need a very strong framework, and I would suggest maybe the committee can develop and suggest a set of guidelines on how the governor should behave according to the law. That this is what the law says, this is what there are many more, as you know, there are many more dicta on this, but the dicta is very clear that you cannot, your discretion is very, very bounded, and ultimately can be only to save democracy and for nothing else. If not, if you continue to do what you're doing now, using that discretion to attack the Constitution, let us be very clear, and I'm using this term as a legal term, not as a colloquial term, because it has a particular meaning which I'll tell you. What is going on is a fraud on the Constitution. Fraud on the Constitution. And technically, legally, the fraud on the Constitution means doing something knowing that it is unconstitutional. Right? Colorable legislation is where you do something which may not be constitutional, but you don't really fully realize it. But fraud on the Constitution has been defined by the Supreme Court in a number of judgments to say it is a species of action where you know something is unconstitutional and you still deliberately do it, and that is fraud on the Constitution. That's what we are seeing now. So a set of guidelines that will make it clear, that will provide a benchmark for every governor. Every time a governor is sworn in, you can present this to him for his information, non-binding, but this is the view of the Council of Ministers and the Assembly. And lastly, I wanted to make a long-term suggestion. Retain the position of president is very important, but abolish the post of governor. It is an appendix. It is an appendix. It has no longer a need. Today, there is no concern that anyone will secede from this country, except the elite. They are seceding by sending all their children abroad, educating them abroad, migrating abroad. They are seceding all the time. The poor of this country will never secede. It's our country, which is born from our anti-caste movement, and we are going to protect it. We are going to, at any cost, we will ensure that it is secure and safe. So I think in the long term, we must start to work for the abolition of the post of governor, so that ultimately, we can work without this nuisance of elected governments having to report everything, to do what they are elected to do. So I think with these 2 or 3 suggestions, I want to thank you again. I'm just exactly at half an hour, which I was given. Thank you very much for your patient hearing. Thank you.